4 children could be in line for a share of their estranged father's substantial estate from a lotto win. New Zealand man David Wade Carson had no contact with his now adult children since separating from their mother in 1974. He left them nothing in his will, gave instructions that no one in his family be told about his death, and created a trust to use some of his money for cattle research. The executors of Carson's estate sought legal advice on their obligations to locate the children, and what information they were required to give. However, before that question could be tested in the High Court at Nelson, a twist of fate led to the children discovering their father had died. One of the man's daughters tried to contact her late father to let him know a sibling had cancer. She found that he had died in 2015, and who the executor of his estate was. The High Court judgment reveals Carson had a substantial estate due to a lotto win. Get the latest news and updates emailed straight to your inbox. By submitting your email, you are agreeing to Fairfax Media's terms and conditions and privacy policy. He had made a family trust which named his children as discretionary beneficiaries. But the trust also has a number of other beneficiaries, including Lincoln University, Carson's stepchildren, grandchildren, spouses or partners of children or grandchildren, nephews and nieces. It was Carson's wish the trust assets be retained and used in the furtherance of research and development of the Galloway breed of cattle. After any gifts have been paid from his will, all his residuary estate passes to the trust, which was set up so members of his family could benefit from the capital and income of the trust from time to time. His 4 natural children have no special entitlement in the trust above any other named beneficiary. However, as the estate has yet been transferred into the trust, the High Court judgment gives the children 6 months to decide whether they'll make a claim under the Family Protection Act. The Act allows family members to make claims if they consider a will has provided adequate provision for the proper maintenance and support of the family members. The High Court ruling states a full list of documents and information will be provided to Carson's children, including a copy of his death certificate, copies of his will and probate, a list of his estate assets and liabilities, a copy of the deed establishing the trust, information about the trustees, and guidance that they should seek independent legal advice. If no Family Protection Act proceedings have been filed 6 months after the children receive the information, the trustees can transfer the estate to the trust. The executors have also been given the ability to have up to $1 million New Zealand dollars, $910,000, put in the trust so they may, at their discretion, provide financial support for the adult child diagnosed with cancer. They note that she may well elect in the future to make a claim against the estate, but in the meantime, funds should be expended to assist her, if required, the judgment said. The executors have also been instructed by the court to find out about the deceased's grandchildren, and whether they had special needs, and whether any application needed to be made on their behalf under the Family Protection Act.